All right. Good morning, everyone. We are here this morning for one special case setting on our August docket. I'm Judge Tom Malone. We also have Judge Catherine Gardner and Judge Rachel Pickering on this panel today. Before we take up the one case, just let me remind the council that we have read your briefs. So we're familiar with the facts of your case and what the issues are. You might keep that in mind as you make your argument. Each side is given 15 minutes for your argument. The appellant's attorney should let us know in advance if you wish to reserve any time for rebuttal. After we hear your arguments this morning, your case will be deemed submitted for decision. And after that, we'll take the case under advisement and get a written opinion out to you and your clients just as soon as we possibly can. So with that explanation, I'll call the case. It is number 127203 out of Sedgwick County. It's Kristofer J. Wright versus the state of Kansas. And who do we have here for the appellant?
May it please the court, Catherine Stevenson of the Capital Appeals and Conflicts Office, appearing on behalf of Mr. Kristofer Wright. If I may, I'd like to reserve 3 minutes for rebuttal argument this morning.
That is granted. And for the appellee?
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas, present and ready for argument.
All right, Ms. Stevenson, whenever you're ready to proceed.
Thank you, Your Honor. Mr. Wright raises 3 issues in his briefing. I'm going to focus on the first 2 issues this morning. The first being that counsel violated Mr. Wright's 6th Amendment fundamental right to autonomy to maintain innocence as the objective of his defense. Mr. Wright was arrested and charged with first-degree murder and conspiracy to commit first-degree murder in May of 2013. Evidence obtained in the case pointed to multiple suspects. Police interrogated Emma Spencer, who, in her first interrogation, implicated Ebony Nguyen as the individual who shot and killed Mr. Turner. Ebony Nguyen was Miss Spencer's then best friend for years. They considered each other sisters. It also came out at trial that Ebony Nguyen was incredibly violent, that she was a drug dealer, that she actually had beef with Mr. Turner in this case, and that she found out that the evening that Mr. Turner was killed, that he had robbed her by providing or by giving her counterfeit money in a drug deal. Law enforcement also interrogated Eric Jackson, who in his first interrogation told law enforcement that Mr. Wright never got out of the vehicle that evening. Interestingly, in subsequent interrogations, both Miss Spencer and Mr. Jackson's stories changed. But what never changed before trial, as demonstrated repeatedly on this record, was Mr. Wright's desire to maintain his factual innocence at trial and to support that defense by presenting an alibi defense. And we know this from the very get-go. He wrote a letter to his first trial counsel early on when counsel was first appointed, stating that he had an alibi defense. In November of 2013, this is volume 12, pages 21 through 24, Mr. Wright puts on the record that he wants the court to be aware that he has an alibi defense, but that his counsel doesn't believe him. We also know that Mr. Wright's second trial counsel who took him to trial, was also aware that Mr. Wright wanted to maintain his factual innocence and present an alibi defense that didn't put him at the scene of the crime. And we know this from trial counsel's testimony at the post-conviction hearing, where trial counsel admits that he consulted with Mr. Wright before trial about the defenses, that Mr. Wright wanted to present an alibi defense, and trial counsel actually filed a notice of alibi with the witness, Mary Andrews, who Mr. Wright asserted all along he was with on the night of the crime.
He wasn't with her the entire night, isn't that correct?
Based on the evidence submitted at trial, there was no alibi defense presented, and the fact that Mr. Wright said that he was with Mary Andrews that night did not come out at trial.
But even she couldn't say he was with her the entire night, correct?
She was asleep, so during her testimony at the post-conviction hearing, she did state that she was asleep and could not be aware the entire night. That's correct, Your Honor. But we know that defense counsel knew that Mr. Wright wanted to present that defense. And so we know, we have him testifying at the post-conviction hearing that in asking him to present an alibi defense, Mr. Wright was telling him that he wasn't there that night.
Let me ask you this, counsel.
Yes.
Does your first two arguments depend upon error in not arguing the alibi defense? Or is it independent? If we find that that was okay for them not, that counsel was not ineffective for not presenting an alibi defense, can you still win on your first argument, or is it dependent upon that?
No, Your Honor, I appreciate the question very much. The alibi defense is completely irrelevant to our first two issues.
So what I'm really interested in are the facts you're relying on to show that his counsel did not present him as not guilty.
I appreciate that question too, Your Honor. So what's critical in addressing the McCoy claim is that McCoy v. Louisiana makes clear that it is constitutional for counsel to argue two different defenses, alternative theories, right? Counsel can maintain innocence and also argue, even if you find that the state has met their burden, there is no premeditation in this case, right? That would be two different alternative theory defenses. However, McCoy v. Louisiana draws a fine line. If counsel knows that it is defendant's objective to maintain his innocence, he cannot concede the actus reus of the crime, right? And so if you read Justice Alito's dissent in McCoy, it makes this point very clearly. Because Justice Alito writes, the fundamental right violated in this case comes down to the difference between the two statements set forth below.
I'm sorry to interrupt, but why don't you steer us to why you think Mr. Mank ceded your client's guilt?
Thank you, Your Honor. I can do that, and I think it actually ties into Justice Alito's dissent. So during closing arguments, defense counsel argues towards the end, he chased him down and shot him in anger, intentionally, but not premeditated. He chased him down and shot him. And
well,
that is
I know you're focusing on that one little part, but in other parts of the closing argument, he seemed to argue his actual innocence, and he closed his argument by saying, I want you to find my client not guilty of murder and conspiracy to commit murder.
Right, Your Honor. He asked them to not find his client guilty of first-degree murder. And that is the same strategy that he took throughout this entire trial. So during jury selection, he told the jury, or he told the panel, the only issue that you're going to have to decide is my defendant's mental state. In the opening statement, defense counsel said, most of what the prosecution just told you happened, but he is not guilty of first-degree premeditated murder. During
Would it be fair to say that Mr. Manx, the thrust of Mr. Manx's argument was that my client's not guilty of anything, but if he's guilty of something, it would just be second-degree murder because there was no premeditation. It was an alternative argument. Do you disagree with that? And if so, tell me why.
Respectfully, Your Honor, I do disagree with that. I do feel that one would have to really put their head in the sand to realize throughout this entire, to read the trial in context, to find that he asserted innocence on Mr. Wright's behalf. Because throughout the trial, including Mr. Manx's opening statement, we know that Eric Jackson was knocked unconscious before any shots were fired. We know that. And so to argue that it's possibly Eric Jackson who fired these shots, there's no evidence to support that. So when he argues he chased him down and shot him, that's exactly what Justice Alito writes is unconstitutional. He makes that distinction. A constitutional argument would be, I submit to you that my client did not have the intent required for conviction of that offense. That's constitutional, whether he argued factual innocence or not. Unconstitutional. I admit that my client shot and killed the victims, but I submit to you that he did not have the intent required for conviction for that offense. And that distinction, conceding the actus reus of the crime, is exactly what McCoy says counsel cannot do. So if counsel disagrees that he wants to present a factual innocent defense, it is constitutional for counsel to argue he didn't have premeditation. The one thing that he cannot do when he knows that his client wants to maintain innocence is to concede the elements of the actus reus, which is that he shot him, right?
But counsel, it seems to me when I read his closing argument, the entire thing, when he's saying it might have been Jackson, it might have been defendant, wasn't he, his purpose, he's showing that the state didn't have any concrete testimony that Mr. Wright was the shooter. And he challenged Spencer's testimony as not credible or not conclusive. Am I misreading that?
I argue that under the entirety of the trial and what he argued at closing, it is not a credible argument whatsoever. Emma Spencer testified. She is the only one who heard the shots fired. She testified that Eric Jackson was knocked unconscious before any shots were fired. And that's volume 18, around page 144. Earlier, volume 18, Eric Jackson testifies, and the prosecutor asks him, were you able to pull the trigger on Turner? And he says no. So he was knocked unconscious. All of the evidence at trial and also what defense counsel argued through trial shows that Eric Jackson was not a potential suspect. What would have been a viable argument and a very strong argument under the facts of this case was that Ebony Nguyen was the one who fired the shots, or at least that the state hadn't met its burden in establishing beyond a reasonable doubt that it wasn't Ebony Nguyen. Because notably, Emma Spencer gives no whereabouts as to where Ebony is. We just know she's outside of the car. Emma Spencer testifies that after the first two non-fatal shots are fired, that Ebony Nguyen says, give me the gun, right? He doesn't point the finger at the one other suspect who it most plausibly committed this crime, the one who had the motive to do so. And so to argue that by potentially saying maybe it was Jackson, it just, under the facts of the entirety of this case, it is so implausible that that can't be what preserves Mr. Wright's fundamental right to maintain the objective of his defense is to assert innocence when he argues maybe it was Jackson. However, Mr. Wright pulled the triggers and shot him later, but without premeditation. that it's not under McCoy. That's a clear unconstitutional argument. And
So, I would, Stevenson, so under your argument, is the defense counsel never able to address specifically premeditation at all?
no, absolutely. I'm sorry. That is not my argument, Your Honor. And I think McCoy, interestingly, this is on page. I apologize. I'm trying to find the pin site, but McCoy speaks to that directly. And it says that this is pin site 424. If after consultations with counsel concerning the management of the defense, McCoy disagreed with counsel's proposal to concede McCoy committed 3 murders, it was not open to English counsel to override the defendant's objection. Counsel could not interfere with the defendant telling the jury I was not the murderer, although counsel could, if consistent with providing effective assistance, focus his own collaboration on urging that McCoy's mental state weighed against conviction. And that's that fine distinction that Alito draws out in his dissent. And they cite to the oral argument transcript that really goes into a little bit more detail here, saying as long, there might be an ineffective assistance of counsel argument later if there's not a factual innocence argument made, but counsel can constitutionally under McCoy not argue factual innocence and stick his arguments, stick to arguing that there was no premeditation as long as there's no concession of the elements of the crime, the act.
Counsel, you've used 12 minutes at this point, so you're getting into your rebuttal time if you wish to preserve it.
I appreciate that. Thank you, Your Honor.
All right, Mr. Gillette, whenever you're ready.
Thank you, Your Honor. The state will focus its attention on issue 1 for the most part as well today. As the court is well aware from our brief, and is set out very clearly in the record, Mr. Mank at no point conceded the defendant's guilt in this case. And one thing that I want to take issue with immediately here today is I've heard opposing counsel argue that even in Alito's dissent in McCoy that a defense attorney cannot concede an actus reus. Footnote 1 in Alito's dissent says the exact opposite. A defense attorney, that is not the rule that McCoy pronounced. Defense attorneys can concede an actus reus or even an element of the actus reus. That's very different than the rule that McCoy adopted. So to the extent that the defendant tries to rely on the dissent from McCoy here today, it does not hold up. Likewise, another issue that does not hold up, I heard argued this morning, was that the defendant at no point changed his position regarding the alibi. On the contrary, it was testified to that Mank and his private investigators spoke with the defendant about the alibi after investigating it. And, quote, this was his testimony, quote, "We elected not to proceed with it for whatever reason. We elected to not follow through with it." So the defendant was informed that the defense was not going to be pursuing this alibi witness.
Is that a very good explanation, though? I think he said something like, "We decided it wouldn't pan out."
I think it is a pretty good explanation when I'd say 2 things. When it's a defense attorney and his investigator that have looked into this alibi, they discuss its viability with the defendant, and then we as a team say, no, we're not going to proceed with it. I think that is strong. I think second, in all of the cases that the defendant tries to rely on here for any kind of a conflict about a strategy, be that McCoy or the others, there is at least some indication somewhere, sometime in the record that the defendant had some express disagreement with a strategy that was going to be employed by the defense. Here, there's absolutely nothing of the sort throughout a voluminous trial.
But he did insist on presenting an alibi defense. Made his desires known for that, correct?
At one point in time, he proposed an alibi witness, yes. But there's no indication that he intended to maintain it after it had been investigated. That just is not the case. And the reason why I think is very clear is briefed. It was my issue too, and I think in response to the defense's issue 3, there was no alibi to present here. Even a cursory investigation into this alibi exposed that it was wholly meritless. The individual in question had no idea where defendant was that night. She had refused to speak to law enforcement previously. She was not credible. The defendant's mother was the other individual that at one point I think had been mentioned as a possible alibi. She wasn't even in the state. She didn't speak to the defendant anytime near the time of the crimes in this case. There simply was no alibi to be presented here. So as the state sets forth in our brief, basically where we're at is that this 2013 murder, we have a defendant that is simply asking this court through some kind of a backdoor or sleight of hand to grant them the rule that Bentley from the Kansas Supreme Court expressly refused to order. And that would be some kind of a requirement that a defendant expressly agree on the record to a defense strategy. We believe that this court is bound by Bentley. We believe that Bentley is sound, it's consistent. I don't have a whole lot to say about Mr. Mank not conceding defense other than the 3 instances that are identified in the defendant's brief are taken out of context. They emphasize fragments of an argument that was clear. As the district court found here, Mank's primary defense was to explicitly argue that the state had failed to carry its burden of proof for the crimes charged. But that if should the jury disagree, then whatever the state had proven did not rise to the level of finding the defendant guilty of the crimes that the jury was instructed upon here.
Let me ask, did defense counsel, or excuse me, the prosecutor ever, no, I'm going to change my question. Did Mr. Mank's counsel ever invite the jury to find him guilty of something lesser than first-degree premeditated murder?
No.
Was there any discussion of second-degree murder charge or any lesser charge with the jury or jury instructions or closing or opening arguments?
Expressly in the closing, I don't believe there was an express mention of second-degree murder. It was just a matter of arguing that, look, whatever happened out on this dirt road and in this field, we don't know. And so there's simply, at best, there was some kind of a fight. There were multiple people outside the car. Nobody knows who pulled the trigger, but that whoever pulled the trigger while that portion of the act, pulling the trigger itself, may have been intentional. There was no intent to kill. And so while there isn't anything, I guess, directly, Mr. Mank doesn't directly say, don't find my defendant guilty of second-degree murder. It's very clear that that was his argument.
Did the state prosecute this at trial under an aiding and abetting theory? If you don't know, that's fine.
Candidly, I'm not 100% sure, but I think in my recollection, and admittedly, the facts in this case have been cursorily discussed at our Supreme Court twice, and now again here, but it does seem that it was more of it was a conspiracy theory, not strictly aiding and abetting.
I only ask because had the state done so, then who pulled the trigger wouldn't have really mattered that much anyway, correct?
Correct.
Mr. Gillette, on similar lines, did defense counsel request a second-degree murder jury instruction?
He did, as well as an additional lesser included instruction, I believe, for voluntary manslaughter that was not given. I think candidly, in fairness to Mr. Mank and the district court here that reviewed his argument, it reads as though he's arguing for that lesser that wasn't given or some other crime that the jury simply could not convict defendant of what they were instructed upon here.
And isn't that sometimes trial strategy to go for, we're only going to go with first degree murder, and if they to find them guilty or not guilty for first degree murder? Strategy versus the lessers.
I think that that's absolutely a possibility. And I think that it can be a viable trial strategy. In fact, I think I have an argument tomorrow that's going to have a similar fact pattern. But here, I mean, even if that had been Mank's strategy, I think it would have been sound. But the critical point that I want to reinforce and just, I guess, close with, if there are no further questions, is that at no point did Mr. Mank cede the defendant's guilt over any objection. We set that forth extensively. This trial was complex. It happened in a fairly quick manner at defendant's urging. There was zero indication of any kind of a dispute or disagreement, even at all, at any point with Mr. Mank's chosen strategy, up to and through, including a direct appeal, a Van Cleve hearing, a Van Cleve appeal. None of this came about until the 1507 motion here. And that is frankly a world apart from McCoy, the cases that apply it, including that cited by the defense in their 609, the Klungel case. This case is simply a world apart from those. And with that, I guess we would fall into the realm then that the defendant would be required to establish deficient performance and prejudice. They've made no attempt to do so here. So based on that, if there are no other questions on the final issue about the alibi, I think I've generally addressed it, but I'd welcome any questions. And seeing none.
Apparently not, counsel. So thank you for your arguments, Ms. Stevenson, whenever you're ready with your rebuttal.
Thank you, Your Honor. I would first like to respond to counsel's assertion that Justice Alito's footnote is good law. That is not the case. That is not the majority opinion in McCoy.
Well, why are we spending so much time talking about Justice Alito's dissent in the first place?
I just want to point out that we have federal case law stating that even conceding one element of an offense under McCoy is a McCoy violation. We have a decision out of the Third Circuit that came down in February of 2025 in which trial counsel attempted to stipulate that his client was a felon, and the Third Circuit held under McCoy that that is not permitted, and the Third Circuit found there is no reason to limit McCoy to all or nothing. Acquittal is just as mandatory when the government fails to prove one element as when it fails to prove all of them. Critically, this case is in line with McCoy. In McCoy, the defense attorney did not believe the preposterous alibi that his defendant wanted to present. And the McCoy court said it wasn't an ethical violation had he presented that preposterous alibi. That wouldn't have been an ethical issue. The issue in McCoy was that once he knew that his client did not want to concede guilt for the lesser, which is what they argued in McCoy, that he didn't have the premeditation, that he couldn't override that by then conceding guilt. So to argue here that Mr. Wright shot the victim without premeditation was the exact violation that McCoy talks about that you cannot do. He could have argued the entire time he didn't have premeditation. He just couldn't say that he shot them. He shot him. That was the critical issue. And I also want to point out, Your Honor, that Your Honors, that Carter remains good law. that the McCoy court actually relied on Carter to make its finding that this does happen routinely, that we are going to see it. And Carter was not overruled by Nixon. So whether this court looks to the fundamental autonomy right to maintain your defense or the distinct effective right to effective assistance of counsel, Mr. Wright is entitled to reversal on both of these convictions because when trial counsel conceded his guilt in closing argument, that violated both of those rights under McCoy and Carter, and the effects are immeasurable, and it constituted a defect in the entire proceeding that requires reversal of both of these convictions. I would be happy to field any more questions from this court if you have them.
So, Ms. Stevenson, just to be clear, the right in the first issue is his right to maintain innocence. Is that correct?
The fundamental autonomy right to maintain the objective of your defense, yes.
All right, so it's objective of defense. And the second issue is your fundamental right to counsel?
Your fundamental right to effective assistance of counsel, which under Carter, which remains good law, betraying your client in this way by overriding his choice in a defense objective is per se ineffective assistance under chronic and requires reversal of all convictions.
Thank you for that clarification.
All right, counsel, thank you very much for your briefs and your arguments today. We really appreciate all the work you put into the case. As I mentioned earlier, we will now take the case under advisement and get a written opinion out to you just as soon as we possibly can. And so with that announcement, today's hearing is adjourned. Thank you.
Thank you.
Thank you.